stuck there all day. She's like never did. Speaking to me. He's about 29, yeah. There's not a whole lot of and there's some right there that you have 4 images in the center of the heart of the heart. We had such a short time, 6 days, I think it's flexible. So we start class on Thursday afternoon. It was well you stopped so on the way over there, it takes a lot of scan. And then all the way back so far over the limit. That's probably it's got about 99 steps. You can see how how are you? Just get something. That's the one thing we did right now. So, and you can see that's the same tree mountain that you saw. I'll show you the other side too. Where you can see the city.
Right, yeah.
All rise. The court is now in session. Be seated, please. We'll find them, Judge.
Well, I know it'll turn up.
Okay. Here's one of ours over here, and we got one in there.
Well, we didn't have to turn up, it's in the courtroom, literally, right. Are you through? I think we're ready to go forward. What will be next?
Judge, if I may, before Mr. Rodriguez goes forward, as our last motion, I hope it's right for me to ask, but we would ask for a written order as to that.
I think we can have written orders of everything.
That's a great thing, Judge.
Whoever wins, practice.
We'll do that right, Judge.
I hope for right this one.
I sincerely hope that if you deserve the right, then you get to.
Good afternoon, Judge, and for the record, Carlos Rodriguez on behalf of Mr. Harris, and I'll be arguing motions, defense motions number 9 and 14. And I'll go ahead and provide the state and the court printed copies of the cases that I'll be citing in my argument.
I have them. And thank you for the cases. And I have those.
I may end up citing a couple of others that I haven't provided the court. If that happens, I'd be happy to provide your staff attorney with electronic copy, and obviously I will CC the state.
That would be appreciated.
Your Honor, I'm asking the court to quash the indictment and find 1612-100 and 1612-103 as unconstitutional, and that they violate the right of privacy and the freedom of speech. This is a facial challenge and as applied challenge to Justin Ross Harris in counts 6, 7, and 8. I think it's important to lay the landscape of the constitutional jurisprudence both in federal courts and in the state of Georgia. First, the right of privacy protects acts of sexual intimacy where they are made in private, they're unforced, they're non-commercial, and they're between persons legally able to consent. That would essentially be straight out of the holding in Powell versus the state. It's 270 Georgia 327. It's a 1998 decision, again, of the Georgia Supreme Court. There, the statute in question was Georgia's sodomy statute. Okay? And this followed the Lawrence v. Texas decision that we all learn about, and that holds that the conduct between two consenting parties, the sexually intimate activity of two consenting parties, where they're unforced, where they're not in exchange for money, they're not in public, and they involve persons legally able to consent, that there is a fundamental right to privacy. Now, I did receive the state's brief in response to defense motions this morning, and I'll do my best to try and pick it apart, but I haven't spent a lot of time with it. But I will say that the suggestion that the right of privacy is not a fundamental right, I think is not supported by case law and the Georgia Supreme Court. In Powell, the court specifically finds that it is a fundamental right. If I can direct the court to page 2 of the printed copy, second column, top of the page, the right of privacy has a long and distinguished history in Georgia. In 1905, this court expressly recognized that Georgia citizens have a liberty of privacy guaranteed by the Georgia constitutional provision, which declares that no person shall be deprived of liberty except by due process of law. Since that time, and I'm jumping down to the bottom of that complete paragraph, since that time, the Georgia courts have developed a rich appellate jurisprudence in the right of privacy, which recognizes the right of privacy as a fundamental constitutional right, having a value so essential to individual liberty in our society that its infringement merits careful scrutiny by the courts. The state, in their response to our right of privacy claim, that the right of privacy is not a fundamental right, that it does not trigger strict scrutiny constitutional analysis, and I'll get to that in a little bit, but it's important because I anticipate that the state will suggest that Your Honor need only look at whether there is a logical reason why the Georgia legislature came up with this very broad statute. And I'm suggesting that's not the law. The law very clearly requires that the court undergo a constitutional strict scrutiny analysis to determine whether this statute, this government-imposed limitation, violates a fundamental right. And so, just to make that perfectly clear, page 4 of the printed copy of Powell versus the state, again, the second column, this is almost halfway down. A government-imposed limitation on the right to privacy will pass constitutional muster if the limitation is shown to serve a compelling state interest and to be narrowly tailored to effectuate only that compelling interest. That's strict scrutiny in a sentence. That's exactly what it is. So, turning now to the freedom of speech, the First Amendment, the First Amendment through the 14th Amendment as applied to the states protects speech that is not intrinsically related to the crime of sexually abusing children. There is a line of cases that deal with obscenity, that deal with images that depict child sexual abuse or child pornography. I'll get into it in detail, but the courts, the U.S. Supreme Court and Georgia Supreme Court said that child pornography does not receive First Amendment protection. Well, I understand that the statute in Count 6 is titled Sexual Exploitation of Children. It's commonly referred to as child pornography. In fact, this statute doesn't simply and narrowly cover child pornography. Child pornography is images or visual mediums that depict child sexual abuse. First, and I'll go all the way back, Judge, okay? Starting with New York versus Ferber. .458 U.S. 747. That is a 1982 decision. Again, the U.S. Supreme Court. There, in a nutshell, distributing and disseminating child pornography does not get First Amendment protection. Okay? And I'm not suggesting that the state doesn't have a compelling interest in protecting children from being sexually exploited or in prohibiting the dissemination, distribution, or possession of child pornography. But 1612-100 goes way broader than that. But to lay out the landscape, the purpose and the interest that the U.S. Supreme Court had laid out was that you don't get First Amendment protection for speech that is related and intrinsically intertwined with criminal conduct. You don't get protection for that. But where speech is related to legal, lawful conduct, you do get First Amendment protection. And the U.S. Supreme Court cases that follow New York versus Ferber and have discussed New York versus Ferber have specifically laid that out. Ashcroft, Attorney General versus Free Speech Coalition, that's 535 U.S. 234, 2002 decision. This case dealt with virtual child pornography. These are images that don't actually involve real children. They involved, I guess, computer-generated looking children engaged in sexually explicit activities. I think it's important to note out that page 4 of the printed opinion, second to last, full paragraph, the first sentence, while we have not had occasion to consider the question, we may assume that the apparent age of persons engaged in sexual conduct is relevant to whether a depiction offends community standards. The age of the person depicted in the images is relevant for the court to consider. The constitutional strict scrutiny analysis. Your Honor will need to determine whether the state has shown that the statute furthers a compelling interest. Not only that, but is narrowly tailored only to that interest. And so now I'd ask Your Honor to, well, it's not very good as far as focusing in on the statute, but 1612-100, and I've laid it out as alleged in count 6 in the motion. That's motion number 10. 1612-100B prohibits, among other acts, any person from possessing a photograph, film, or visual medium that depicts a minor or a portion of a minor's body engaged in any sexually explicit conduct. Interestingly, although the statute is titled Sexual Exploitation of Children, nowhere in the statute, in that code section, is children defined. Instead, it's minor, which defines a person under the age of 18 years. And obviously, that encompasses 16-year-olds and 17-year-olds, which are both legally able to consent to sexual activity. But a government-imposed limitation on both the right of privacy and freedom of speech must pass strict scrutiny analysis. So the compelling interest here must be to protect children from being sexually exploited and abused. Okay? New York versus Ferber has confirmed that as a government compelling interest. The use of children as subjects of pornographic materials is harmful to the physiological, emotional, and mental health of the child. However, the conduct that is the content of the photograph is lawful for two legally consenting parties and also lawful under the exceptions to B. So I'll move to those. Specifically in 1612-100D, the provisions of subsection B of this code section shall not apply to the activities of law enforcement and prosecution agencies in the investigation and prosecution of criminal offenses. And 2, legitimate medical, scientific, or educational activities. I think it's important to point out that at least the legislature has acknowledged that as a category, images that depict minors engaged in sexually explicit conduct is not as a category something that cannot be possessed. They've acknowledged that there's potentially legitimate medical, scientific, or educational activities. But third, any person who creates or possesses a visual medium depicting only himself or herself engaged in sexually explicit conduct. The exemption in the statute itself suggests that the creation of the image is not unlawful. The person that creates or possesses a visual medium only depicting herself or himself engaged in sexually explicit conduct is not a crime. I would submit to Your Honor that it is not only protected by one's right to privacy to be able to create this visual medium doing whatever they would like as long as it's lawful, depicting lawful conduct in the privacy of their own home. There's that. But there's also statutory exemption under the same statute permitting this activity, making it lawful. So, whether it's narrowly tailored to further that compelling interest of protecting children from sexual abuse, from sexual exploitation, well, the statute isn't narrowed to only children. The statute is expanded, so that can't serve as the government's compelling interest, because there must be a compelling interest to prohibit the possession of images that are lawful for the creator to make, that are private, that are unforced, non-commercial, and done by someone that is legally able to consent to the very sexually explicit conduct that is the subject of the images. The statute does nothing to further the state's interest in protecting children from sexual abuse by criminalizing the possession of an image that's protected by the right of privacy and the freedom of speech. The wide net of 1612-100 reaches far beyond what is necessary to only protect the welfare of children or shield them from sexual abuse. If that really was the state's compelling interest, then the statutory age would have been 16. And if that really had been the state's compelling interest, then it would have been unlawful to create an image that depicts a minor engaging in sexually explicit conduct. After going through a constitutional strict scrutiny analysis, the court can then decide whether the statute can be narrowly construed, narrowly limited and constructed to avoid an unconstitutional result. The Georgia Supreme Court in Howard versus the state, that's 272 Georgia 242, a 2000 opinion that followed Powell and had to do with the solicitation of sodomy statute. Well, the Georgia Supreme Court upheld the solicitation of sodomy statute so long as the statute could be narrowly construed to only punish speech soliciting sodomy that is not protected by the Georgia Constitution's right to privacy. But when both the object and plain language of a statute make it insusceptible to a limiting construction, courts in Georgia and the U.S. Supreme Court won't rewrite a law to conform it to constitutional requirements. In this case, it's impossible to avoid the plain object of the statute, which is to encompass the lawful and constitutionally protected activity of those legally able to consent, because it specifically says that it's a crime for someone that is at least 14 years of age, that includes 16 and 17-year-old, created with the permission of the minor depicted, so defendant is possessing an image with the permission of the 16, 17-year-old that created the image. Defendant's violation did not involve the distribution of such visual medium to another person, okay, meaning it was for private, personal use, or if it did involve the distribution of such visual medium to another person, it wasn't for the purpose of harassing, intimidating, or embarrassing, or for any commercial purpose. Private, personal use, or if it wasn't done with the purpose of harassing, intimidating, or embarrassing the minor depicted. This separate provision of the very same statute explicitly makes clear that even if you're 16, even if you're 17, even if you are of the legal age to consent to sexual activity, and even though it is perfectly lawful for you to create the image, by someone else possessing it, even with your own permission, made in the privacy of your own home, for their own personal use, unforced, non-commercial, not in exchange for any money or to be disseminated into the market, it's still a crime. I've set out some examples in motions 9 through 14. Now, 9 and 10 are specific to count 6. But 1612-100B8 prohibits, for example, a 20-year-old military officer stationed at Fort Benning from possessing a nude image of his 17-year-old wife or girlfriend. For purposes of the statute, it makes no difference that the 17-year-old wife or girlfriend took the photograph and texted the photo via her cell phone directly to her boyfriend or husband. The 20-year-old officer is guilty of a felony under 1612-100B8. There's no exception for married persons. There's no exception for willing, lawful, personal and private use of these images. I know that the state will suggest that we don't have standing to argue on behalf of hypothetical third parties. I think we absolutely do in arguing that a statute violates the First Amendment. The traditional standing requirements have been laxed to allow someone that is actually subjected to punishment in the application of this statute for raising the facial constitutional issue, unconstitutional issue on behalf of third parties to prevent the chilling of free speech and exercise of their rights. Even the cases that the state cites in their own brief stand for that position. I know that it is included as a footnote in their brief, but it's very much a part of the constitutional jurisprudence. So, in sum, the conduct that is the content of the photograph, well, moving to an as-applied challenge in count 6, Judge, as applied to Mr. Harris, the conduct that is the content of the photograph is lawful for two legally consenting parties, and it's also lawful under the exceptions to B, and that was 100D3. In contrast to the speech in fervor, speech that itself is the record of sexual abuse, 1612-100 prohibits speech that records no crime and creates no victims by its production. None whatsoever. The statute is not narrowly tailored because it does not limit its scope to images of children being sexually exploited or abused. exactly what Ferber and Ashcroft stand for. And we know that because of U.S. v. Stevens. I provided a copy to Your Honor. That is (130) Supreme Court 1577, a 2010 opinion. Judge, there it makes clear that just calling something child pornography doesn't all of a sudden take it outside of the protection of the First Amendment. If that were the case, if simply calling something child pornography allowed the state to restrict speech however they wanted and as much as they wanted, then presumably they could set the statutory age for child pornography at 21 and suggest also that if you look like a child, then we can also punish you for possessing child pornography. That's not the case, because the Supreme Court doesn't simply say that if it's child porn, if the state calls it child porn, then it doesn't get First Amendment protection. Instead, what takes speech out of the protection of the First Amendment is if it is inextricably tied to criminal conduct that is depicted in the images. And that is supported by the interest that Ferber made clear, is that the state must have an interest, or must have the ability to stamp out the exploitation of children, exploitation of those children that have already been abused. Well, 1612-100 goes way further than that, because it's not limited to children. It's not limited to those under the age of 16. The suggestion that the state has a compelling interest in protecting 16 and 17-year-olds from making unwise decisions about photographing or filming themselves in engaging in sexually explicit activity. What undercuts that argument is the simple fact that it's not outlawed. 100D3 specifically allows for the creation of these visual mediums, these images that only depict himself or herself. Now, I know that the state will draw your attention to some courts out in the Midwest that have decided to overlook U.S. versus Stevens. The dissent points out, and I believe it's the Hollins case that the state will ask Your Honor to consider. There, counsel never raised a First Amendment challenge. For whatever reason, counsel conceded that there wasn't a fundamental right, that there wasn't First Amendment protection that is afforded to images that do not depict unlawful activity. But I'm making that argument. This absolutely is protected by the First Amendment. Back to the as-applied portion of our challenge to count 6. The alleged victim in this case was at least 16 years of age at the time of the alleged offense. She was otherwise legally capable of consenting to acts of sexual intimacy. The defendant would be guilty of no crime for requesting in person and having sexual intercourse with the alleged victim, but would be guilty of a felony for merely possessing a sexually explicit photograph that she absolutely wanted him to have. I'd like to point out that count 6 is interesting in that, and very creative in that, it is not alleged as a completed offense, but in conjunction with the attempt statute. the defendant's alleged request does not constitute a completed offense under 1612-100B1, which makes it unlawful for any person knowingly to employ, use, persuade, induce, entice, or coerce any minor to engage in sexually explicit conduct for the purpose of producing a visual medium depicting such conduct. Presumably it's because all of the evidence and discovery has at least indicated that there was no persuasion, no coercion, no undue influence, but this was a willing participant, one that even encouraged these sorts of communications. But by alleging that defendant's alleged request of a nude image constitutes a substantial step towards violating 1612-100, the states manipulated the criminal attempt statute to criminalize what is lawful in B1. In the very first provision of 1612-100B, it's not unlawful to request. But by morphing the attempt statute with B8, they're making what is lawful conduct, and they're alleging it as unlawful conduct. I think that effort on behalf of the state shows how, as applied to Mr. Ross Harris, this is unconstitutional. That's to B6. B8, excuse me, count 6. Now, motion, you want me to just go through 11, or do you want the state to respond to 9 and 10, and then I get back up and do 11 and 12?
I don't mind hearing the state on that.
Your Honor, I would prefer to argue all at the end. The same overarching argument is made with regard to all 6 motions about the age of consent versus the age of a minor and the sexual exploitation and dissemination of harmful material in the minor statute. So I would prefer to do it all at the end.
I think that's sensible.
Okay.
And apparently it's consistent with what you're prepared to do.
Yes, ma'am. Motions number 11 and 12, those pertain to count 7. Count 7 specifically is charging defendant with knowingly disseminate and furnish to the named victim, a minor female under the age of 18 years, printed matter containing explicit and detailed verbal descriptions and narrative accounts of sexual excitement and sexual conduct, which taken as a whole is harmful to minors. Okay. 1612-103A makes it unlawful to knowingly to sell or loan for monetary consideration or otherwise furnish or disseminate to a minor any printed matter which contains explicit and detailed verbal descriptions or narrative accounts of sexual excitement, sexual conduct, and which taken as a whole is harmful to minors. Oddly enough, the legislature has determined that it is harmful to minors to write down what can be legally spoken to in person, or about conduct which they can legally engage in. A 16 or 17-year-old can lawfully engage in sexually explicit, if the majority of the public wants to call private sexually intimate activity as explicit, they can, but if it's in private, if the person is of the age of consent and it's lawful, it's protected by the right of privacy, and any discussion about that, which 1612-103 is absolutely a content-based restriction in that it specifically goes to the content of the communications between the parties. State versus Cafe Erotica, that's a Georgia Supreme Court case, and I've provided Your Honor with that copy. 269 Georgia 486, a 1998 opinion. If I may move all the way to page 3 of the printed opinion. Footnote 5, we need not decide today whether the General Assembly may set the age of majority in piecemeal fashion by establishing an age of majority in individual legislative enactments. What we decide today is that when the General Assembly sets an age of majority based on the content of expressive activity protected by First Amendment, that legislation constitutes a restriction on the right of free speech and must meet the strict scrutiny that is required of content-based restrictions and regulations of speech. Okay? So very clearly does the Georgia Supreme Court indicate that 103, that statute, is a content-based restriction. And so it does trigger constitutional strict scrutiny analysis, which would require the state to show a compelling state interest, and that this statute furthers that and only that compelling state interest. 1612-101, its own statute sets out what the legislative purpose is for 1612-103. And there, the legislature points out that it has an interest in not only protecting minors, but protecting the general public from minors being harmed by harmful materials. Stanley versus Georgia, that's 394 U.S. 557, a 1969 case. It's a U.S. Supreme Court case from Georgia. But the court there says, if the First Amendment means anything, it means that a state has no business telling a man sitting alone in his own house what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds. Well, Judge, that interest also applies to the, although yes, minor for purposes of the statute, but it does apply to that person's interest as well. They have a fundamental right to free speech and a right to see or hear whatever they want in the privacy of their own home. Stanley versus Georgia stands for that. And so when a 16, 17-year-old that is legally capable of engaging in adult sexual intercourse wishes to see or read or view an image that is sent to him or her in private, that is encouraged or requested, a willing participant, the First Amendment protects that person's right as well. It's not just the person that is sending out that message. Now, the First Amendment, I'd submit, absolutely protects the person that creates the description or creates the photograph that is sent that the state wants to prosecute under 1612-103. But the statute still has to satisfy the strict scrutiny analysis. So the compelling interest in preventing or shielding the public from aggressive public dissemination of harmful materials that may fall into the hands of children, that obviously can't be the compelling interest in this case. Because although the evolution of 1612-103 seems to suggest what it was really going after was shops that are selling pornographic films and the possibility that children could be exposed, that's not how 1612-103 is limited. obviously, as it is one of the charged offenses in this case. But it is so broad that the statute cannot avoid restricting speech or conduct that is regarding lawful sexual activity between persons legally capable of consenting to the described sexual activity. It's not for money or any commercial purpose, and it's unforced. I'll ask Your Honor to also consider whether the statute can be narrowly construed. Once going through the strict scrutiny analysis, again, the courts have to determine whether the statute can be construed to avoid an unconstitutional result. Because the definition of a minor for purposes of 1612-103 includes persons aged 16 to 17, the statute can't be read to avoid such an unconstitutional restriction on private, unforced, non-commercial communications of sexual intimacy. The plain language of 1612-103 makes it a crime for any person to text or email with a willing and participating 16 or 17-year-old describing sexual activity that both parties are lawfully permitted to perform. Using the same players in my first hypothetical, a 20-year-old military officer stationed at Fort Benning is prohibited from describing his sexual excitement and lawful sexual intentions upon seeing his 17-year-old girlfriend for the first time in 6 months. Interestingly, there is a statute that prohibits obscene telephone contact. Now, the statutory age for that statute is 14 years old. A 17-year-old wife or girlfriend can be on the phone with her 20-year-old husband or boyfriend, and they can whisper sweet nothings about sexually intimate activity, but they can't text message about it. But they can't email about it. I know that laws don't have to make sense. They don't. But they can't violate the Constitution. And the reason that they don't make sense is because that's exactly what these statutes are doing. They're violating a person's right to privacy and free speech. As applied, 1612-103 prohibits defendant from privately communicating about sexually intimate conduct with a willing participant that is legally able to consent to acts of sexual intimacy. The alleged victim in this case was at least 16 years old as at the time of the alleged offense in count 7. She's otherwise legally capable of consenting to acts of sexual intimacy. However, as applied, Mr. Ross Harris is subject to a statute that prohibits discussion about the very same sexually intimate acts that they're lawfully permitted to engage in. As to count 8, that is a text message of a nude photo. It's the same arguments as to count 7. That 20-year-old soldier from Fort Benning can lawfully expose his genitals during intercourse, but can't send his wife a photograph of them. Even though she wants that photograph, even though it's made in private, it's unforced, it's non-commercial, in the privacy of his home. State versus Cafe Erotica, which I cited to earlier, makes it clear that 1612-103 regulates speech and that it denies the speaker an unlimited audience, and it denies those between the ages of 18 and 21 the right to determine whether they will view the expressive activity taking place within that place of business. Here, 16 and 17-year-olds are denied discussing, seeing what they are constitutionally permitted, and in Georgia, lawfully permitted to engage in. So what is the state's compelling interest in prohibiting a willing recipient that is legally capable of consenting to sexual activity from receiving and reading a detailed description about sexual activity or a photograph that depicts something that she can or he can see live in the flesh? Miller versus California, which is one of the more important U.S. Supreme Court decisions in laying out the obscenity test and laying out how statutes can constitutionally regulate obscene material. And that's 413 U.S. 15, a 1973 decision. The states have a legitimate interest in prohibiting dissemination or exhibition of obscene material when the mode of dissemination carries with it a significant danger of offending the sensibilities of unwilling recipients or of exposure to juveniles. The mode of dissemination that 1612-103 covers is so broad that it includes the private mode of dissemination, one that doesn't carry with it a significant danger of offending the sensibilities of unwilling recipients or exposure to juveniles, because it covers those that are legally capable of consenting. Final Exit Network Incorporated versus the state, that's 290 Georgia 508, 2012 case. That statute criminalized an offer to assist in suicide. And the Georgia Supreme Court found that that violated the First Amendment. Why? Because suicide is not a crime, and at the time, many assisted suicides were either not prohibited or expressly exempt from the statute. The state there wanted to argue that the statute was intended to prosecute assisted suicide in certain cases and that the statute is justified by the state's compelling interest in preventing suicide. Well, here we're talking about lawful activity, speech regarding lawful activity. If the state wanted to prohibit the discussion of that activity, they could have by prohibiting that very conduct that is the subject matter of the speech, that is the subject matter of the conduct that is protected by the right to privacy. Judge, last I will leave Your Honor with a quote from Ashcroft versus Free Speech Coalition. The government may not suppress lawful speech as the means to suppress unlawful speech. Protected speech does not become unprotected merely because it resembles the latter. The Constitution requires the reverse. Having a statute so broad as to encompass constitutionally protected speech is not justified just because it is a convenient way of prohibiting unprotected speech or unprotected expressive activity. For those reasons, Judge, I'm asking you to quash the indictment, grant motions 9 through 14, and find counts 6, 7, and 8 unconstitutional and that they violate the defendant's fundamental right of privacy and freedom of speech, and also as facially overbroad, both to the fundamental right of privacy and to the freedom of speech. Thank you.
Thank you, Mr. Rodriguez.
Your Honor, I'm going to argue the next motions, a motion or a series of motions. I have an old school PowerPoint. I wrote a hearing brief. I served the copied hearing brief on the defense. I'd like to serve a copy on you as well. My primary argument today, Your Honor, is going to go towards the sexual exploitation of children statute, but it really applies to all of them. And it's kind of a global argument because the thread through all these challenges, all these motions that the defense has filed is that the age of sexual consent to commit sexual acts in Georgia is 16 years old. These acts define a minor as under 18 years old, and they're complaining that the difference between those two ages is unconstitutional, essentially. Basically, their argument boils down to this, Your Honor. If the age of consent to sex in Georgia is 16, an adult in our state has a constitutional right to possess or create or receive sexually explicit photos or videos of 16 and 17-year-old kids. That's essentially what it boils down to, a constitutional right to do that. Now, I was doing a lot of research over the weekend on this. I was writing this hearing brief and doing a lot of research around the country, and I noticed that the age of consent in most states is 16 years old. Federal government is 16 years old. There's a few outliers. New York is 17. Colorado is 15 if the 15-year-old is having sex with someone who's less than 10 years older. But generally speaking, around the whole country, it's 16. Also, if you look around the country at the child pornography statutes or the sexual exploitation of children statutes, they almost universally, I couldn't find an exception to this, universally define a minor or a child as under 18 years old. That difference exists around the whole country. It exists in the federal government and the federal statute. It exists in really every state I could look at or I could find. So this type of argument has been made before in other states. It's been made in Georgia. It's been made in other states. Georgia has actually addressed this before. Multiple courts have rejected it around the country. And what you didn't hear from Mr. Rodriguez's presentation, which was excellent, was any citation to any court in any jurisdiction that actually bought this argument. There's not a single case or a single court around the country who has found a child pornography statute or a sexual exploitation of children statute unconstitutional because the age of consent is lower than the definition of a minor in that statute. The Eighth Circuit Court of Appeals has addressed it and rejected it. The Illinois Supreme Court has addressed it, this exact argument, and rejected it. The Nebraska Supreme Court has addressed it and rejected it. And our Georgia Supreme Court has addressed it before and rejected it. And the case in Georgia is Reed versus the state. It's at 264 Georgia 466. And what happened in Reed, Your Honor, is that in fact it's almost exactly like count 6 in the indictment. Reed was charged with and convicted of attempted sexual exploitation of a child under the sexual exploitation of children statute. The victim was a 17-year-old married female. Reed made the argument, essentially it's an equal protection argument, which is similar to the argument that the defendant is making here today. And I'll just quote it. Reed asserts that he is similarly situated to defendants who are charged with other crimes against children, and that he is subject to disparate treatment because the statute under which he is charged criminalizes conduct involving all children under the age of 18 years, whereas other crimes against children specify a lower age threshold and in certain instances implicate only unmarried victims. Essentially, that's the argument that the defendant's making here today, that he's treated differently because the victim is 16 or 17, whereas if he was engaging in sex with that person, it wouldn't be a crime. Trying to elicit a sexual image from that child, he's alleging should not be unconstitutional. And the Georgia Supreme Court rejected this argument in Reed. They found that there was no equal protection problem. And that, like I said earlier, that's essentially the same equal protection argument that the defendant is making here today. Now, constitutionally, child pornography depicting actual children is not protected by the First Amendment. There is no constitutional right to make or possess child pornography. The U.S. Supreme Court's been very clear about that. The Ashcroft opinion that Mr. Rodriguez cited says very clearly, the freedom of speech has its limits. It does not embrace certain categories of speech, including defamation, incitement, obscenity, and pornography produced with real children. Count 6 alleges that the victim is a real child, obviously. These categories can be prohibited without violating the First Amendment. Now, in Ferber versus New York, which is one of the cases Mr. Rodriguez cited in Osborne v. Ohio, the United States Supreme Court upheld child pornography statutes in, obviously, New York and Ohio against First Amendment challenges. And our statute is similarly worded to both those statutes. These cases have stated that even if arguably there was a de minimis First Amendment right to child porn, its prohibition easily meets the strict scrutiny test. And what they said in I think it was Ferber, was that even if arguably defendant has a First Amendment right to possess child pornography, its prohibition would meet the strict scrutiny test. And our Supreme Court, and the case is Amman versus the state, A-M-A-N, is at 261 Georgia 669. Quote, it upheld our pornography statute, our sexual exploitation of children statute. And the quote in here, and how it meets the strict scrutiny test, even if we had to apply the strict scrutiny test, in later cases they said just rational basis, because there's no constitutional protection for child pornography. But the quote is, we find this case distinct from Stanley, which is a case Mr. Rodriguez talked about, because the interests underlying child pornography prohibitions far exceed the interests justifying the Georgia law at issue in Stanley. It is evident beyond the need for elaboration that a state's interest in safeguarding the physical and psychological well-being of minor is compelling. The legislative judgment, as well as the judgment found in relevant literature, is that the use of children as subjects of pornographic materials is harmful to the psychological, emotional, and mental health of the child. That judgment, we think, easily passes muster under the First Amendment. It is also surely reasonable for the state to conclude that it will decrease the production of child pornography if it penalizes those who possess and view the product, thereby decreasing demand. Now, later courts have said that you really only have to apply a rational basis test. There's no constitutional protection for child pornography. I'm just going to quote, this is one of the cases I'm going to talk about a little bit later. It's the Eighth Circuit Court of Appeals case in United States versus Bach, B-A-C-H. It's cited in my brief, but it basically says the First Amendment does not prevent prosecution for child pornography, and Congress may regulate pornography involving all minors under the age of 18 if it has a rational basis for doing so. So we don't apply a strict scrutiny test. We apply a rational basis test. Now, we've heard a lot of talk about 20-year-old GIs with their 17-year-old girlfriends, 25-year-old men with 17-year-old wives, as talked about in the amended motion. But when the United States Supreme Court was considering the constitutionality of the New York and Ohio child pornography statutes, they specifically declined to go down that road and started imagining scenarios where the statutes might cover protected speech. In Ferber, the argument was that maybe it might cover medical textbooks that depict nude children. In Osborne, the complaint was the Ohio statute might cover innocuous photos of naked infants. And they said, we're not going to do that. We're not going to do that because the reach of the statutes was plainly directed at hardcore child pornography. The defendants were on notice that their conduct squarely fell within the statutes, and because child pornography involves conduct as well as speech. And here's a quote from Ferber about that. When they rejected going down, we don't have to imagine scenarios under the overbreadth doctrine when we're talking about child pornography. There's no First Amendment protection for child pornography. And they said particularly, and this is right out of Ferber, particularly where conduct and not merely speech is involved, we believe that the overbreadth of a statute must not only be real, but substantial as well, judged in relation to the statute's plainly legitimate sweep. So you don't have to do that. You don't have to sit there and imagine what 25-year-old husbands and 17-year-old wives may do. The defendant clearly does not fall into that category. Your Honor only has to consider how the statute may be unconstitutionally applied to the defendant, and is not unconstitutionally applied to the defendant. He falls squarely within the category. His alleged conduct falls squarely within the category of what is prohibited under the statute. Now, as I previously said, the exact issue involving the age of consent versus the statutory definition of a minor in a child pornography statute has been raised and rejected before in other jurisdictions. This exact argument has been made before around the country and has been rejected. In the Eighth Circuit case, United States v. Bach, Bach was a 41-year-old man,
He took photographs of a 16-year-old boy who was nude and engaging in sex acts with Back, and Back possessed the images, transmitted one of the images over the internet. The same argument that we're hearing today was made in that case. Nebraska v. Centers, it's a Nebraska Supreme Court case. Centers was a 28-year-old man who videotaped himself having consensual sex with a 17-year-old girl. The videotape was discovered by Centers' roommate and the police were notified. In Illinois v. Hollins, Hollins was a 32-year-old man who was convicted of 3 counts of child pornography for photographs he took of him having consensual sex with a 17-year-old girl. All 3 of these defendants complained specifically, like the argument we heard today, that these children were photographed were willing, they consented, they're over the age to consent to sex acts. All these defendants argued that a constitutional right, including a right to sexual privacy, as in the Lawrence case that Mr. Rodriguez talked about, and every single one of these courts rejected those claims. Every single one of these courts said there's no constitutional right to make or possess child pornography depicting actual children, and there was a rational basis for the distinction between the age of 18 in the child pornography statute and the age of consent being 16 to engage in sexual acts. And the Illinois Supreme Court in the Hollins case, I think, said it best. So I'm just going to read what they said here about how the difference between the age of a minor in the child pornography statute and the age of consent, there's a rational basis for establishing it as 18 in the child pornography statute. And they said, quote, there are rational, reasonable arguments in support of having a higher age threshold for appearance in pornography than for consent to sexual activity. And then they give the reasons. The consequences of sexual activity are concrete and for the most part readily apparent to teenagers, possible pregnancy, sexually transmitted diseases, and emotional issues. Many, if not most, teenagers who are 16 and 17 will have been apprised of these consequences by parents or sexual education classes in school. The dangers of appearing in pornographic photographs or videos are not as readily apparent and can be much more subtle. Memorialization of the sexual act makes permanent an intimate encounter that can be distributed to third parties. These concerns are exacerbated in the modern digital age, where once a picture or video is uploaded to the internet, it can never be completely erased or eradicated. It will always be out there, hanging over the head of the person depicted performing the sexual act. And they said, although Hollins, in this case, said he never intended for this videotape to get out, he meant for it to stay private, the court said there's no guarantee private photographic images will always remain private. For a variety of reasons, one's private material can someday be made public, whether by accident, theft, or the actions of a scorned former partner. Setting the age of consent at 18 for appearance in pornographic materials is a reasonable, rational approach to protecting children from sexual exploitation and abuse. Child pornography is not rationally protected, or not constitutionally protected, Your Honor, and Georgia has a rational basis for preventing children from under 18 from being depicted in these images. And therefore, the state argues, Your Honor, that you should deny all these motions because it is not unconstitutional to set the age of a minor as under 18 in these statutes. Thank you.
Thank you, Mr. Clinton. You have a response, Mr. Rodriguez?
In Reed versus the state, and in Nebraska and in Illinois, it was raised as an equal protection challenge. I'm not suggesting that Mr. Ross Harris is a member of a suspect class. That's why we're not arguing that this is an equal protection violation. But the courts have made clear that a content-based restriction must be analyzed under strict scrutiny analysis. So Reed doesn't apply. Bach, Centers, Hollins, they don't apply. I want Your Honor to not simply gloss over the instruction from Ferber, Ashcroft, and Stevens. It's not simply calling something child pornography that takes it outside of the protection of the First Amendment. It's something more than that. It's a special kind of case where there is speech that is pertaining to unlawful activity, where the speech is so inextricably connected, it is intrinsic with the crime that is depicted. There is no crime depicted in these images. 1612-100 is so broad in that it covers photographs that are made in private that do receive protection by the First Amendment, the right to privacy. The state says the compelling interest in protecting children. You can't possess child pornography and still get First Amendment protection. That's absolutely right. We're not suggesting that child pornography ought to be protected by the First Amendment because we're not talking about child pornography in our case. I'm not suggesting that 1612-100 doesn't cover child pornography. It absolutely does, but it goes well beyond that because it covers conduct that is lawful, that does not sexually abuse children. Images that do not sexually abuse children are not child pornography. They may depict minors, but for purposes of Georgia and apparently many other jurisdictions and the federal government, they are persons that can engage in lawful adult sexual activity. I do want to respond to the argument that there is a compelling interest in preventing future crimes or future harms. The prospect that someone may take that privately possessed image and disseminate it, and therefore we ought to prevent the creation and the possession of it altogether. Well, the state can't make that argument when the Georgia statute in question exempts the creation and possession of that very image. If the state was truly concerned with that interest, that exemption wouldn't be there. But it is. And as far as I know, those statutes in Box, Centers, and Hollins didn't have those similar exemptions, lawfully permitting the creator to make and possess an image that even depicts a minor, by him or herself, engaged in sexually explicit activity. That very same argument was made in Ashcroft. Page 11 of the printed opinion, the end of the second to last full paragraph, the government has shown no more than a remote connection between speech that might encourage thoughts or impulses and any resulting child abuse. The reality is that speech, discussion, the photograph as applied in count 6 does not sexual abuse of a child. And so the argument that by not affording someone First Amendment protection for possessing which depicts lawful activity is justified because of some future potential harms. Again, Ashcroft dealt with that very argument and said, look, there are many things innocent in themselves, such as cartoons, video games, and candy that might be used for immoral purposes. Yet we would not expect those to be prohibited because they can be misused. It is a broad attempt to prohibit unlawful conduct by conveniently covering lawfully protected, constitutionally protected speech.
Proposed orders from both sides on this within 1, 2 weeks. Well, which 2?
Would it be possible to get the transcript?
Well, someone asked me, I'm not going to write it.
Would it be possible to get the transcript?
Did you talk to you about that? All right, get the transcript and then say within a week of that. Will that work for everyone?
Great, Your Honor.
And in any event, before the next motions dates, like about maybe a week before the next motion dates to me so that I can have them done before we come back to court?
Sure, I'll work with the same one.
Very good. All right. Any motion, are we ready on that?
State's ready.
Which one are you talking about?
Yes, motion made, Demir.
Go ahead. Are you ready?
Yes, ma'am.
Okay.
Whenever you are.
Always ready.
Defense. This is the count alleging the attempt to commit sexual exploitation of children. I made an assumption that the state step towards committing B1. However, that the defendant is charged with an attempt towards committing provisions 1612-100B, and even within provisions, multiple of committing violating 1612-100. So simply, an indictment is subject to special demurrer when it is not perfect as to form or when the accused is entitled to more information. Where a crime may be committed in more than one way, the failure to charge the manner in which the crime was committed subjects the indictment or accusation to a proper special demurrer. Here, the manner in which the offense is alleged in count 6 does not sufficiently put defendant on notice of the manner in which 1612-100 was committed, therefore not perfect as to form, by providing the accused with the information to which he is entitled.
Start off with on the demurrer to count 6 of this indictment. I'll turn your honor first to the standard regarding a constitutionally sufficient indictment. The group court held, when it addressed the challenge of attempt to commit aggravated child molestation and criminal attempt to commit child molestation. It contains the elements of the offense intended to be charged, sufficient against him for other or similar offense, whether the record shows with there was a challenge to the insufficient name in the indictment. In that case, the Supreme Court reviewed the indictments and found them valid as a whole, all of the indictments. This is a case where the Court of Appeals had actually sustained the grant of a demurrer. The Supreme Court said, no, we are reversing this, and that these indictments are appropriate. Going just to the criminal attempt counts, to let Your Honor know how they were charged, because that's specific to the count they're alleging is insufficiently indicted. Those counts alleged the attempt to commit a crime, the violation of a Georgia statute. In one of the counts, aggravated child molestation. In the other count, child molestation. And also that a substantial step had been taken toward the commission of that crime. Basically, for criminal attempt counts, those are the two statutory things you have to set forth. The crime that is supposed to be violated, not necessarily all the elements, but the specific crime cited to, and then that a substantial step was taken. In that case, I would note that the indictments, which are listed out how they're indicted in the case in GRU, did not in any way allege the elements of aggravated child molestation or child molestation, which the defense's demurrer basically alleges is the problem here, that we should have alleged every specific element in the indictment of 16-12-100. That's not the case in a criminal attempt case. In that case, the elements did not allege that a child was under 16 years of age. The indictment that was held valid did not the acts were for the intent to arouse the sexual desire of the accused or the child. And also, as to aggravated child molestation, the criminal attempt indictment did not allege what type of act of sodomy, as there are different ways to commit sodomy, did not allege the attempt was to perform that act. The Supreme Court held that all three counts follow in large part the language of the statutes GRU was charged with violating, set forth dates of the alleged crimes, and set forth with particularity the acts constituting the offenses so that GRU could prepare a defense. They also held that the indictment satisfied the dual goals of informing the defendant of charges against him and protecting him from possible second prosecution. Judge, that's exactly what we have here in this case. We have an indictment that alleges substantial step toward committing that act. The defense has argued that in their motion, when a crime can be committed in more way than one, motion cites Jones versus, or State versus Jones, which is 246 Georgia Appeals 482, to decide that because this specific statute could have been violated in two ways. Basically, you could have given a hand signal to violate it or an emergency